The number one reason business owners lose money in commercial litigation has nothing to do with the merits of their case. It actually comes down to one decision they make long before they ever walk into a courtroom. And in over 30 years of doing this, I have watched most business owners get that decision flat out wrong. Now in this video, I'll walk you through the exact 6-part filter I run every business dispute through before I let a client file a single document in court. And by the end, you will know whether your dispute belongs in front of a judge or whether the smarter play is to settle, walk away, or find another path entirely. All right, let's dive into this one. I'm Santiago Cueto, board-certified international business law expert and best-selling author based right here in Miami, Florida. Now, I've sat across the table from hundreds of businesses who are furious, certain that they had been wronged, and absolutely ready to sue. And some of them should have. Most of them should not have. The reason why most of them should not have is the framework I'm about to hand you. Inside my office, we call it the Litigation Triage. It is a 6-part filter every business dispute has to pass before it earns a spot on the court docket. When a dispute fails the triage, you settle, you walk away, or you just find another path. When a dispute passes the triage, you file and you fight. Now you're probably thinking, but I have a strong case. Is that enough? Well, here's the thing. A strong case is not the same thing as a worthwhile case. And that is exactly where the first criterion comes in. The first filter is what I call the Collectability Test. Before I file a single document, I ask one question. Can the other side actually pay? Because winning a judgment against a defendant who has no assets, no insurance, and no income is what I call a phantom verdict. You walked out of the courthouse holding a piece of paper that is technically worth $1 million. The judgment is real, but the money's not. Now, I've watched business owners spend a fortune in legal fees to win a 6-figure judgment against a shell company with 0 assets. The verdict lives forever on the court docket. The recovery never arrives. That's not justice. That's an expensive trophy. Now, stop suing people who can't pay. Run an asset check, a UCC filing search, and a corporate background investigation before you draft a complaint. And when the defendant fails the collectability test, the dispute fails the triage. It's that simple. Now, the second filter is the math floor. Every business dispute has a number underneath it. Below a certain dollar amount, the cost of litigation will swallow the recovery whole. Run this calculation before you sign an engagement letter. Take the realistic recovery amount, subtract expected legal fees, and subtract expert witness costs, and subtract the value of the time your team will spend in depositions, document production, and trial prep. What is left over is your actual recovery. Now here's where it gets interesting. When the final number is negative, you have just discovered a Pyrrhic victory in the making. You will win the case and lose the money. That is a loss no matter what the judge says. The reason why this criteria matters is simple. Litigation is a business decision, not a moral one, and your bookkeeper does not care who was right. She cares what hit the bank account. Now, the third filter is the exhibit file. I ask every client the same question on day one. Show me the paper, not the emotion, not the verbal promise, not the gut feeling, the paper, the signed contract, the dated invoice, the wire confirmation, the email thread, the text message with the timestamp. When the paper exists, your case has support. When it does not, your case has a story. And stories lose at trial. Exhibits and proof, they win. Now you're probably thinking, but we shook hands. We had a relationship. They knew what they agreed to. Well, here's a brutal truth. Florida courts do not enforce handshakes. They enforce evidence. When the exhibit file is thin, the dispute fails to triage, and settlement is a smarter move. The fourth filter is the strategic layer. Sometimes you sue not to recover the money, but to send a message, to protect a trademark, to establish a precedent that stops the next thief from copying your playbook, to deter the partner who is watching from the sidelines, deciding whether to make the same move. Now, when a lawsuit serves a strategic purpose beyond the dollars, the math floor stretches. So a 6-figure case can justify 7 figures legal spend when the precedent it creates protects future revenue. But this matters. You must name that strategic purpose in writing before you file. Otherwise, the lawsuit just drifts. It becomes about ego. And ego is the most expensive client a lawyer can have. Now, quick reminder, if this framework is sharpening how you think about your next business lawsuit, hit subscribe so the next playbook lands in your feed. Now back to the criteria. The fifth filter is the clock. Every business claim has a statute of limitations. In Florida, the windows are short and unforgiving. When the clock runs out, your right to sue is gone forever, regardless of how strong your case is. And the reason why this matters more than business owners realize is that the clock often starts running long before they notice the harm. A breach of contract clock can start the day of the breach, not the day you discovered it when you waited too long to call a lawyer. The dispute fails the triage by default. Stop sitting on disputes. The moment you suspect a breach, get the clock checked. The sixth filter is the emotional filter, and this one is the hardest. Before I take a case, I ask my client to answer honestly. Are you suing to recover or are you suing to punish? Punishment is not a legal remedy in most business disputes. The courts do not award damages for betrayal. They award damages for documented losses. When the dispute is driven by emotion rather than economics, the case fails the triage almost every time. You will overpay your lawyer, you will reject reasonable settlements, and you will chase the verdict instead of the recovery. And in the end, you will write a check to your own attorney that dwarfs the check you ever could have collected from the defendant. So those are the 6 criteria of the litigation triage: the collectability test, the math floor, the exhibit list, the strategic layer, the clock, and the emotional filter. When a dispute passes all 6, you file and you fight. When it fails even one, you find another path. That is the difference between a business owner who uses the court as a tool and one who is used by them. Now, if this is useful, hit subscribe so the next playbook lands in your feed. I'm Santiago Cueto, your Florida business attorney. Watch this next video where I reveal whether you should settle a lawsuit or fight it out in court, and the decision can cost you everything.